Hello and welcome to TCLF's One-on-One Series, where we try to bring you the finest insights from distinguished professionals across fields. Today, we are delighted to have with us someone whose remarkable journey has taken him from the bar to the bench and back again. He has had and continues to have an illustrious career. It is our privilege to welcome retired Justice Challa Kodanda Ram to our podcast today. Sir, welcome.
Good morning.
Good morning.
And thank you very much for inviting me and giving me an opportunity to share my thoughts and my life journey to you all youngsters.
Right. So the journey of 1,000 miles begins with a single step. While this may sound a little cliche, but we still want to ask, what was that first step for you? Can you share what initially inspired you to pursue a career in law? Were there any pivotal moments, influential figures, possible mentors?
To just start with my journey, basically I was not a very good student at school, college, and I did my graduation in science from Bangalore University. But the university is not important. The institution where I studied is more important. It is a Satyasai Institute of Higher Learning in Whitefield, Kadugudi, Bangalore, which is run by the Satyasai Institution Trust of Satyasai Baba. My father has put me there because I was a little mischievous man and all through was a little unruly type of person. So my father said discipline is more important in the life. So he put me there. And probably some of the values which I picked up is from my father. So my father said education is not important, the character is important. He has put so much emphasis on character. Education really wasn't much to say. So I finished my graduation, and then destiny took me to Visakhapatnam on account of trying to make a living. And in the process, I ended up working with an industrial concern, which is a running industry, manufacturing of forgings and general works, which was being run by my brother-in-law. So I joined him more as a errand boy, helping him in everything, going to bank, buying things which are required for industry. And there's no job which is not done by me at that stage. So whatever my brother-in-law told me, I have done. I went for marketing, I went for purchases. And about 7-8 years, I spent in the industrial sector. And in the process, I also started a industry myself. Those days, it was about 10 lakhs investment, which my brother-in-law has put. I had about 30-40 people working. The general engineering workshop. I know quite a bit of about fabrication and machining of components. We were doing works for the Hindustan Shipyard, BHP, and steel plant was under construction stage at this stage. Being youngster, I was traveling extensively on motorcycle and trying to get orders and trying to learn engineering aspects of the business. So in that process, at that point of time, out of necessity, I was in the industry as well as some working. I initially worked also in Port Trust as a tally clerk, while cement being imported by the state of AP. I was a tally clerk near the unloading point on behalf of one of the stevedoring agent. I spent about a year there. And at that particular point of time, casually, one of my friends met and said, I'm doing law, night college. So I also said, why not? Can I join night college? Yeah, what all, you are working somewhere, get a certificate. you are working so and so, you will get into things. That's how I entered into law course in the night college. It's more to be in the university campus than to learn law or to study law. 3 years passed. I passed out of law and I got a degree. Frankly speaking, it was Allahabad learning. 30 questions at a glance that time. I do not know the 30 questions at a glance books exist today. Because 3 years law is actually not there. It's a 3 years law. And then I continued in the business. I never thought of coming to practice. Sometime in 87, I got out of my brother-in-law's fold and I started my own business. I was involved in the civil construction. Then after about 8 months or so, I was making good, but at one particular work, it was a bad work, which I lost about 10 lakhs in those days. And that's all borrowed money from friends. So I shifted base from Visakhapatnam to Hyderabad. And I did not know what to do, and I was just looking for any other opportunity. Then I went to my uncle. My uncle was a former Chief Justice of Andhra, Justice Challa Kodanda Ram, who retired in 1980. So I went to him and asking him for a job. My uncle said, "You got a law degree, why don't you go and practice?" That was something bolt from blue for me. But my uncle being an elderly person and I had no other option, I said, okay, I just nodded my head and called my friend. We both went to Bar Council and enrolled myself. And then it so happened, after the 4th day or 5th day of my enrollment, I ended up with again my uncle's house. One of the industrialists had come to my uncle for some advice. So he gave me a big file of mining related matter. I just looked into, he said, you study. My uncle had always a positive attitude. He always encouraged. If I do 10%, he will say, oh, he's a brilliant boy. He does this, that, all. That way he, quite a bit. He told the other person, oh, he's my nephew and he's a brilliant fellow. He knows this, that and all, practical knowledge. All kinds of boostings he had given. And he gave me the big file and said, go and study. I was cursing myself what kind of ended up in this. But I went and looked into the file. It was quite a bit of file, almost about 500-600 pages. I just sat with a pen and paper and being in business earlier, I had a radical approach of looking into what are the important events. So I jot down all the important points and then I went and told my uncle and client that this is what I think is my view of it. Then something happened. That man, the entrepreneur who came, he said, I told you this boy is a brilliant boy. See how he got the point. How he got the point. He arrived at the crux of the matter. Then my uncle said, see, just empty words will not help youngsters. Why don't you give him some money? So he pulled out a checkbook and he gave me 10,000 at that particular point of time. 10,000 was a big money for me at that point of time.
Must have been a king's ransom.
So I took that. And then to realize later, as I journeyed through the case and all, what exactly has happened is, this particular client of mine had gone to various senior counsel. Every senior counsel looked at that particular case from the point of view, and they said, you have no case. I was the only one who told the way he was thinking like a businessman.
So that certainly tells that your experience prior to joining the law has had a great impact as to how you continued practicing law.
Yes.
And that is true for lawyers, that they not just practice law, but they also have to know professions other than the law. Now, sir, that definitely tells us as to how your practice went, and we understand that you had a broad array of practice, at least on the civil and the commercial side. Of course, we also know about your criminal practice. But sir, there was a time when you had been designated as a senior advocate prior to you being elevated to the bench. Now, the question that comes to my mind, and this is something I haven't been able to grapple with, is that if someone has become a senior advocate and who's being engaged to argue, then what is that fact which compels them to take the offer and to get elevated to the bench? What is that tipping point which pushed you? Possibly it is to serve the country, and that is what I believe it is. But I would like to hear it from you, sir.
Yeah. Before that, I should also tell you something has happened, that the initial case is all right. Thereafter, because I come from basically, my father is a person who became MLA in 1952.
Okay.
And he continued to be MLA all through till 1978. And he was also a cabinet minister in the erstwhile, the Honorable Prime Minister, former Prime Minister, P.V. Narasimha Rao, as well as thereafter with Mr. 𝐓𝐿 Rao. But my father is a stickler, and he is one of those, today sometimes I feel hesitant to tell my father was an MLA. The reason is MLA or MP politician means people, the minute they say, oh, that means because of that, you are what you are, or probably you have made so much of money, kind of thing. Unfortunately, that's the kind of the taboo today politicians carry. My father belongs to the old generation, absolutely honest man and absolutely man of integrity. That's why he always emphasized only on one thing: education or no education, money or no money. Character is important. Character is the one which drives you, and that's the one which is required to be an individual in the society. So with that background, then I entered into profession, and fortunately, I also joined a senior, Justice Parvatra, who became a later the judge of the High Court. He was also a particular person who had been to Oxford in 1955 itself. After he came back from Oxford and he started his practice, he stickler to the procedure, stickler to the core values, hardcore. I should also be. I don't hesitate to say he was a hardcore young man. He had all the things. He had great kind of integrity person. He could have become a judge in 1980 if only said, "I'm leaving my political affiliation with RSS." That time he was offered to share. He said, "No, that is my ideology. I don't leave it." With the result, he did not become a judge at the age of 43, 42. Though it was offered to him. He later became a judge sometime in 1990, because he was one of those well-known lawyers. My senior had an extremely good work, especially every branch except criminal branch. It so happened, and after I joined the office, after 1.5 years or 2 years, he became a judge. Then the office came to the old work, whatever was pending work was with us. Except that with the pending work, what happens is you acquire a lot of files, but the revenue point of view, it's not there. Because they already, unlike in Delhi or Calcutta, where they pay on every time, in Hyderabad, it is a lump sum once in the either beginning or in the end they pay. So I could not ask any of my clients the money which already been got existing files. But what has happened is at that particular point of time, the people who became judges, they're all very highly talented people, along with my senior, that particular batch. So on everyday basis, there are at least 10-15 cases getting listed, and we are already every time we are on the top of the list because of the years which they are there pending. Instead of asking for time or instead of engaging a senior, every day I used to sit up to 1 o'clock and read the files, and next day, without asking for adjournment, go and argue. Thereby, what happened is, in first 3 years itself, though I joined profession in 1988, by 1991, Nobody thought I am a junior, just 3 years old. Because of the opportunity which I had a challenge to argue every case. And previous night you said, read, go and argue, and the variety of cases. There is no branch which is left, and it used to come as a income tax case. The judges were Justice G.O.P.T., Justice P.Venkata Ram, Justice K. The various people in the AP was once upon a time admission of the repetition was a great difficulty. First question which they would ask is maintainability. So that challenge has made me tough, and by 96, I was so well entrenched into the thing. For the first time, I took a break and went to Singapore. I stayed there in Singapore for 10 days, and I went around, studied the Singapore system.
Nice.
I spent about 10 days and then I returned back in 96, 97. I was feeling vacuum. In 98, I joined one of the life coaches. There's one of my friend, one Mr. Shekhar Agarwal. He was running a organization called Success Unlimited. So I went there and he said, my wife joined first, then I joined. First day he said look here, you came here to be coaching. So next 3 days you are under my control. It's about almost 40, 50 people. And you should do whatever I tell without question. Then next 5 minutes, what he said is start jumping. I jumped so much. He said, you are very, very sincere in what you are doing. I said, I came here to be coached.
I believe that comes from being instructed by clients. We are always following instructions.
True. That day, something happened. He made me to, not only me, entire of the group. He said, now you sit. Write down what you want to be 25 years from now. And then he said, okay, 2025, what is it you want to have? And I started laughing and I said, what is all this nonsense? 2025, how can I imagine? And he was not leaving. He said, everybody stood next to them. Come on, write. And I said, okay, let me take it seriously. In 2025, I wrote Attorney General of India.
Oh.
Yeah. From 2025 to backwards, I worked out.
Yes.
Very seriously. Then I said I should become a senior counsel by 2006. I should be designated as a senior counsel for 2006. From 2006, after designated as a senior counsel, if you want to become Attorney General, naturally you'll have to be recognized by the government. So you need to be at least additional Advocate General, and then additional Solicitor General, Attorney General. So that day I mapped out entire of journey up to Attorney General. He forced me to do it. That set a goal for me. And then what is it if I am Attorney General? What is it I am expected of? I should be thorough in constitutional laws. I should be thorough in taxation. I should be thorough in various aspects. So from that day, I started again equipping myself with respect to that particular knowledge in that particular way to be that journey of 2025. So I actually made it by instead of 2006, I was designated in 2009 for the reason at that point of time in Andhra Pradesh, to be designated as a senior counsel, you should have completed 20 years of standing.
Right.
So I joined in 88. 20 years gets completed in 2008. In 2009, I was designated as a senior counsel.
Right.
Immediately, I thought of shifting to Delhi. Solicitor General also, somebody was ready to do that. But various reasons in the family, I didn't do it. 2012, I became actually a resident of Delhi. But then the question which you asked, what made you to accept office?
Yes.
2012, it was Justice Lokur who made me to accept office. In 2004, I had an offer to become. I refused because I needed money, I needed comfort which money gives. I also needed to support my family because my father did not make money. My brother, the family, he was also not settled. My brother's children were not settled. And my cousins who were struggling. We were a joint family. Even today, we continue to be a joint family. So I needed so many family issues. I said, no, I'm not interested in leadership. 2004. Again, in 2007 and 9 also, I got opportunity. 2009, I dilly-dallied whether to accept or not. But interestingly, one of the senior counsel told me, by the time I was graduated, he said, they see, the people want you to kill your practice. That's why they are giving you the judgeship. You have already made it to so big. And it's like, you know, this snake and ladder story.
Yes.
That game. So you're already in the almost reaching the pinnacle of your career. The possibility of your becoming additional Solicitor General and Solicitor General, whatever it is, etc. But now what they are doing is, by offering you a judgeship, they are putting you in the mouth of big snake mouth. So you will be coming down completely. Again, you will be starting the career and you will never be able to make it to the pinnacle. Don't accept. I really liked the senior counsel's analogy and I came back and said, sorry sir, I'm not interested. Didn't cheat basis. But 2012, earlier all the people who asked me to accept office, they said, salary is not that bad, you have other comforts, and you have respect, etc., etc. But when Justice Lokur is concerned, mark my word, is very, very important, and that's the youngsters, all of you. When you get an opportunity, probably this should be the reason for you to accept office. Any office for that matter. What he said to me is this. Today, in the society, there are 3 or 4 power centers which give the direction to the society. Political leadership is one. Bureaucratic leadership is another one. Then so far as your military power and those things is another one. Other wing is the judiciary. Carefully think on these 4. So far as the military and army is concerned, it is a different aspect. So they protect the country from the external aggression. So far as the political leaders are concerned, they are the people who are supposed to be thinking for you, your society, not for you, me, society as a whole. What is needed in the society and how do we govern the society? How do we make the better society? How do we create the better society? What he said is, today, unfortunately, that political leadership has gone completely away. That leadership is not there. The leaders are only with respect to their party or for themselves, etc., etc. They are not thinking, and there's no proper leadership for the country. Okay, somebody wants to become prime minister, somebody wants to be this, somebody wants to be that. All for their own reasons, but not for the sake of country. Committed the leader for the country, like my father. My father was MLA not from 1952 to 1978, and he was a qualified chartered accountant. Yet he left that and he was there committed. And when my father died, we got only about 2.5 lakhs in 1981 as a family. You can imagine that kind of thing. So that political leadership is not there. Bureaucrats who are supposed to guide the political leaders, they have also completely given up their role. And there is no planning from their point of view. They are only worried about their own career, their own transfer, or many of them, except a few. There are always exceptions. The earlier days, otherwise was exception. Norm was service. Today, service is an exception. otherwise is none. So he said this wing and this wing, both who are supposed to lead the society, they have gone bad. The judicial wing, which has the power to control both, at least to keep them in line, this is also collapsing and crumbling. One of the reasons is good people not getting into the bench. And if you people don't accept, these are his words, this is what made me think. If you people, good people, don't accept the office, and if you don't sit in this chair, I have no choice to select from whoever is there. And in their hands, your judiciary and your system, your society will end up. And just imagine what is going to be your children's and your next generations, and the society, kind of society. Does this kind of structure of society, does it exist at all? Is the question which he asked me, and he said, think it over and come back. I'm not saying this post is good and all. You are already making good money. You are already very well established, and so much of work you have. In fact, it is a disservice for me to tell you on that angle. But the need for the society, for your own children, for your own way, to ensure that structure doesn't collapse, good people should come and accept. Not to allow the undesirable elements to occupy that seat. And this was very inspiring talk for me, because by the time I was really in a peak of my career, and the next phase would have been a really phenomenally growth. Today I see my colleagues, my other colleagues who are there, like the people whom you know, Mr. Niranjan Reddy, and they're all my juniors. I was at least about 8-10 years senior to him. And there are so many other people who are, whom you know very well, my batch people, even Justice Challa, and many of the who are there today, the Solicitor General, they're all my batch kind of people. This Lokur's inspiring words, and today I'm really convinced about what he said.
It's not just inspiring to you, but I'm sure many of us watching this would also draw inspiration from here. So that was a good segue onto how you landed on the bench. Now, serving as a High Court judge, I presume, had its own set of challenges. Now, what were some of those most significant challenges that you faced and how you tackled them? It could be both on the administrative side as well as the judicial side.
Well, brother, so far as the period which we served as a judge in the High Court of erstwhile combined Andhra Pradesh, and thereafter divided two-state High Court, thereafter the independent High Court of Telangana. There were 3 phases. When we became judges, there were hardly about 14-15 people. And then the Chief Justice is from outside, and the Chief Justice is a man, very committed man, Justice 𝐓𝐂𝐋𝐅. But at the same time, that particular time, this bifurcation of the state, agitation was going on. So he had to face a large number of challenges for non-cooperation from some of the judges, the court, and head of lower judiciary not cooperating. And then there is a political agitation. Every day there is something or other in this local, non-local, the separate rights being claimed, etc. But in spite of that, we were churning out good amount of work. But the challenges so far as the trial court work is concerned, virtually no work was in the trial courts because of the agitation, and the agitation was being spearheaded by some of the advocates from the High Court. They are all so much committed to that statehood they are not bothered about their practice. They're all quite well-to-do people. Their money is not an issue for them. And it's also an, ideological commitment of wanting to have a separate state, etc., etc. So we had that tough time. And then that phase is over, by which time, in the interregnum period, what has happened is, not many names were being proposed for elevation. Because the separation issue. So for almost about 8 years or so, we were functioning with less than, it's about 1/3 strength. Within that 1/3, again, there is an inherent inefficiency in our system of elevation to the High Court judges. As a system, I'm not talking about any individual kind of. What happens is, the strength of the High Court judges, the 2/3 from the bar, 1/3 from the service. Now, at the level of service, there's an element of the providing for constitutional guarantees of reservation, etc. So in that process, whatever maybe one may speak, I do not hesitate to say, but not that the people reservation category people, there are no good people, but in the process, there's an element of efficiency quotient less gets into. Number one. Number two, after they become the district judges, over a period of time they work, and then when they get elevated to the High Court, they get elevated in the last 1 year or 2 years. So 20-25 years, they already, all the district judges, they with fatigue. No more commitment is there with respect to when they become a thing. I'm not talking about any individuals. Many of them, because of my close friends, I asked them, why can't you put a little more pressure? He said, no, we have already been doing it for the last 20 years. We just came. The approach is always that. So again, when they come, all right, we are going to retire in next 1 year or 2 years. What is there for us to look for? So that is also brings in some element of inefficiency into the system. But then balancing regional in the 2/3 people whom will get also. Again, the same thing again falls into play. Apart from the real the competent people not getting onto the bench for whatever reasons. So that overall in the High Court level, it again brings in some element of inefficiency. Let us say 20-20%. In addition, at any given point of time, there is a 1/3 or more than 1/3 vacancies. Even today, if you see country as a whole, you can one of you can Google and see how many vacancies are there in the High Court levels. Though the SOP as well as the Supreme Court larger bench judgments after the SP Gupta's case, as categorically said, 6 months before itself, you will have to start the exercise and you should ensure that by the date one retires, there should be always automatic filling up. Is it happening? It's not happening. You can see today, just 2 minutes, you can Google and see how many vacancies are there in the High Court across the country. And that, again, each state, if you look at, again, this kind of thing is there. And our High Court, it has happened much more. With the result, we were more often confined to the firefighting rather than addressing the system as a whole. Therein the system inefficiency again steps in. So these were the challenges which we faced. Then, in addition, for everything today, it has become, the High Court has become, you need to go, you get some mandamus. I want to buy a matchbox, but you don't get an order that I buy a matchbox. The individual officer level, the commitment is there, and there is no accountability. The superior officer does not have the guts to take to task to the subordinate officer. For everything they want, you won't get an order, we'll implement. If there are, in state of Telangana, when I left, there were 7,000 contempt petitions pending. That is something, 7,000 contempt petitions means the system is not being effective. That tells about the thing. Personally, I am very strong about the order not being implemented. But many of the orders are what? I call it as a consider and dispose of jurisprudence. We are trying to solve individual problems rather than systems problems. In the name of giving justice to the individual or citizen, I strongly believe in the High Court level and Supreme Court level, it has to be because they are creating precedents. So they should address to the systems rather than to individual cases or giving individual relief to the individuals. If they pronounce a judgment, that should be in such a way that, yes, with respect to these class of things, this is the what finality. Unfortunately, I do not think, personally, my personal opinion, I stand corrected. What is being done in most of the time is individual problems are being solved. Okay, a judge says that I disposed of 10,000 cases. I disposed of 50,000 cases. Already we have disposed of so many number of cases in Lok Adalat. But question is, why is so many cases getting generated is the question which the constitutional court should ask and correct that particular point rather than trying to tackle the individual cases and trying to do justice to that. They're all working very hard.
That's right. So in fact, what you say, it's quite intriguing because recently, in April, in fact, of 2024, a report has been published by the Department of Justice. And according to that, high courts across the country have 327 vacancies against their collective sanction strength of 1,114 judges. So that does speak to it. In fact, sir, you bring us to a very important question with respect to the sanction strength being low and the number of cases being instituted being sufficiently high or significantly high, which does bring in the other problem that we face in the Indian judicial system, that of pendency. Now, this brings in the question of roster management as to how the judges themselves coordinate and ensure that matters get disposed of. Now, I remember in a past conversation that I had with you, you were informing me about some sort of a mechanism that you had developed in order to reduce pendency and to bring in efficiency in your roster. So could you tell us a little more about how you went about doing that and what exactly that was?
Well, see, when it comes to each of the judge, they get allocated a particular subjects or a particular roster. On a, sometimes it all depends on the chief justices and also their active participation in trying to reduce the pendency. And most of the chief justices, they are very committed and they try to each one tries to their own mechanism. But what I feel is, as a central system, probably the lead can be taken by the Supreme Court. It need not be a Chief Justice. Chief Justice has so many things. The Supreme Court and involve the judges across this thing, which is being done. But at the same time, each of the time new Chief Justice comes, he comes out with his own. He comes out with his own pattern. And the minute he goes out, that pattern dies.
Yes.
Again, new this thing. That is because probably the sufficient thought is not given to them. And I always ask, and I keep jocularly telling my friends also, I have no fear of being castigated by anybody, point of time or any point of time. I'm open in expressing my opinions. Why does a particular Chief Justice or a particular judge only after reaching Supreme Court gets bright ideas? Why doesn't he get this idea at the stage when he is elevated, the day when he is elevated? And why does he doesn't put forward in a openly, these are my ideas, maybe they are worth considering, please consider. Is it not that kind of freedom is not there when I become a judge, High Court, Supreme High Court judge? Maybe district judges know that. They are afraid. There's a lot of, it's a typical of police department, how it is about insubordination. There, even in judiciary also, that kind of mentality is still there. Forgetting that we are independent, nobody can interfere into my judicial decision, quiet judicial decision. Yes, my administrative decision is concerned, somebody can interfere, but not judicial decision. Judicial decision can be only upset in a judicial process by the appellate authority or revisional authority or whatever it is, but not as a quiet, as an individual judge in the administrative side. If that is the issue, there are so many things which, dynamic way system can be, but the main, the very at the stage of filling itself, filling up of the post itself, we are stuck. So instead of even 1,100 or 1,200 sanction strength is not sufficient, because the most of the today in the high courts, the 226 is the panacea for everything. 226 and 227. I don't blame the citizen. For the simple reason, that's the only method. See, in a classic case, which right now, which is being dealt by one of my office colleagues relating to a particular land, only identity of the property is an issue. And the case is pending for 20 years. The simplest thing is that identity of the property, what is this one? Probably in a 2 days' time, it can get over. But we still follow the old traditional system of the plaint, written statement, thereafter the examining of the witnesses, same the routine way, rather than in an out-of-box way. And then we do not also follow the strict CPC procedure. I had an occasion to study the procedure in US, UK, as well as in India in relation to some cases. In US and other places, same the way you file either plaint or your claim and their response. And thereafter, both the advocates are supposed to sit together and exchange of documents. Thereafter, the interrogatories, most important aspect. Interrogatories and discovery. Once interrogatories and discovery is over, admission and denials of the documents at that stage gets over, then both the lawyers are the ones who are supposed to sit and then say, these are the only tribal issues. The responsibility is fixed on the lawyers with respect to narrowing down the tribal issues, and it is only on that tribal issues the matter goes for a trial. Whereas in India, what is your name? What is your father's name? It starts off with that. And then naturally the cases don't go forward. And then at every stage, there is a cost involved. Because the cost involved, people, they take a call. And it is the responsibility of the lawyers to file an affidavit before the court in the Western countries. We have made all efforts, and except these things, nothing else is there. And speaking untruth is a perjury and very serious offense. Whereas in India, now you know for your own experience, everyone files affidavits, false affidavits. Tell me in how many cases of perjury are reported in India? Statistics. In how many cases really courts have really punished in contempt cases?
They
So
are
the
kept
indulgence
pending.
shown by the court, the one which encourages dishonesty.
So unlike the traditional way, probably now they keep it pending and hanging as probably Damocles' sword on the head And when the moment is ripe, probably it will be dropped. But they do not see their fruition. The cases do not see their end with respect to contempt, with respect to perjury.
No, there are no perjury cases. How many perjury cases are there? Take the statistics and see. And execution petitions, 20 years you take for the suit to be decreed, and thereafter the execution doesn't, no courts, there are no specialized courts for execution. There is no mechanism. Same judges, same thing. Then how do you expect to have the faith in the judiciary? That results in a different way altogether. Anyhow, that's the challenges which we faced are the questions which is being asked by your client and you are not able to answer. That's the biggest challenge. And when I look at the points, talking points, this thing in front of me, virtually there are not much of significant challenges. I did not face any challenge with regard to handling any roster. Whatever is given to me, I have done, and I have done well. At least I believe so.
While I understand there may not have been any significant challenges on your part, but let's suppose someone who's a junior judge or who has just made a judge and is made to sit on a roster that he or she may not have had prior experience in. And as a junior judge, I am not particularly aware if one has much say as to the roster one would handle. Then in such a situation, how do judges go about it?
Well, I see. You mean to say that you are sitting in the division benches or in the single?
In a single bench.
So
or both for that matter.
You are in the single. As I said, you are entitled to err. Question is, are you making effort or not?
Correct.
Number one. Number two, what do you mean by roster when you say a particular subject?
Correct.
Now, you tell me, in India, how many acts are there where 600 or 800 sections are there? To your knowledge, maybe company law and?
Maybe the IPC as it existed before. And maybe even with the new enactments of
all right.
3 criminals.
So ultimately, you can count on fingers?
Yes, that is right. At least to the best of my limited knowledge.
So I'm putting you a question. That's the reason how I dealt with many of my cases, asking the questions to the advocates and making them to arrive at the answer.
Right.
So, except in exceptional cases, you do not have, in most of the cases, the acts are 30 questions or 30 sections or 40 sections at best. Right. Out of that, it is a enactments where at least 10-15 sections are relating to employment and staff, etc., which really may not much, except in service matters. When it comes to all other sections, there are again procedural sections. There are also definition section. You know, as a lawyer, you know how to skip through, arrive at the court. So if really one puts an effort, no roster is difficult. I never felt any subject to be any difficulty. Only thing is, I again go back to write an examination in that particular subject over a night.
Oh.
2-3 nights I study entire of the act and all the landmark judgments reported on that particular. And most of the judgment also, if you see the judgments per se, again with the caveat, because people should not misunderstand me. Most of the judgments are all what? They just explain this is the section, this is the section, this is the section. What is the interpretational element there? You are applying to a particular set of facts and thereby you are creating, you are disposing of a particular case and thereby you are treating it as a precedent.
Right.
Is there any interpretation per se in the section? No, you go back and think about the precedents which you are coming. 90% of the cases, what is the precedent? That is, in peculiar facts of the case, applying that particular section, the case was disposed of like that. So when you go to before the court, You also say it again, try to say it and say, look here, this is what it is earlier decided. No, what is decided? There is no interpretation per se there.
Right.
That is the view taken by that court at that particular point of in that particular facts of the case.
Right.
So I never believed anything to be a really a hardcore precedent which is required to be adhered to.
Right.
If that is the case, how much time really you take to get adjusted to a particular roster? A day or two. I never faced any problem in adjusting to any roster. Because as I said, I'm going for examination in that particular subject, that particular act, overnight.
Right.
That's how it is.
Right. So now that you have gone through the full circle and now you're back to the bar once again, now how does their experience at the bench help you now? And how do you see yourself different from what you were prior to being on the bench?
Honestly, I never ceased to be, even on the bench, I never ceased to be an advocate. So there is not much of a difficulty in transitioning back. Because as I said, every day I was going for examination in a particular subject, in that particular. Only thing is, as a judge, I was dealing at least about 10-15 varieties of subjects on a day-to-day basis and 70-80 cases on a day-to-day basis. And then I always, I believe no precedent is really unbreakable. Because I only need to study carefully. I should thank my senior for that, who inculcated that habit of analyzing critically every judgment and analyzing it the way it is required to be analyzed. So I was never afraid of the precedent. It's again fresh approach. And another important thing is, I'm not worried about the volume of the brief, for the simple reason, every case is there to be tackled an individual set of facts. That's one. And second thing is, it depends on the facts of that particular case to be dealt with and law. And I don't claim to be a subject expert, but I say, what is your USP? I always say that, well, I'm expert in that particular case for that particular client on that day. Because see, even you are a doctor, you are a best surgeon. Let's say previous day you had 4 pegs extra, and next day you go for surgery. What will be your focus in performing the operation?
Right.
So what is important is that particular case when you are dealing that day is what matters rather than your previous knowledge or your knowledge you may have, all erudition which you may have.
So essentially every day you begin with a clean slate and use the experience that you have had to the best you can. Now, sir, it's intriguing because you mentioned about your senior, and this has happened through the course of this interview, the podcast. What I wanted to ask is that today, mentorship by and large is a very rare phenomena at the bar, which is something that should not ideally be. Now, in your time, and I know for a fact that you have mentored many juniors who are today excelling at the bar. What is your perception of mentorship, and how do you think the present status of mentorship can be made better?
Well, slightly, it's not that there are no mentors. The very system, maybe the national law schools and also the intelligence here which is getting into the profession. Maybe even up to our stage, there was always, they used to say, my senior used to say, the seniors used to say, that they all ended up in law because, in fact, Justice 𝐒𝐄𝐑, the one who rendered that Sarita judgment, one of the brilliant brains of the country, as I know. I believe the first day in the class, law college, I believe, well, boys, you're all here because you could not have been anywhere else. Law was the last choice.
Yes, last resort of the refuge.
Yeah. So, no, not only law course was the last choice. somebody joining law. But from that to today, thanks to national law schools, there is an element of the euphoria brought out, and also the career prospects have grown tremendously. And the large number of intelligent people who could have gone to engineering, who could have gone to medicine, they wantonly are choosing to be in the legal profession. At least they're studying law. They may join legal profession, they may not join legal profession, they may go to something else. But law has a basis, they're coming back. It's like going back to pre-independence days in India. See, these kind of the but at the same time, because they spent 5 years in the law school, and because they see few of the very successful people who have made it in this thing, it could be a law firm or here, there, all. They all feel that we all know better. We don't need to learn anything. And they do not understand, that we require an element of mentorship. Where the people who come to me or who join me, fortunately, I had about 40, 45 people whom I trained. All my, colleagues and my juniors, they are doing extremely well. What I always tell them is, first thing even now I have few of the interns with me. 5 years over, they do not know where to start in the litigation or in the law. No doubt, they are extremely good in computer. First thing, anything I think, they open up their laptop. I say, why are you opening up your laptop? Why don't you take the book? It's much easier for you to take the bare act and read through in 5 minutes or 15 minutes, 20 minutes. I know, I'll tell you how to read the bare act. Just now I told you, that in an act, if you analyze, the core meat will be maybe about 5 or 10 sections. The rest of the things are all, that how to skip. But whereas what you do is you try to look for a precedent. You are very good in searching. But that searching, does it help you at all? You need to learn the skill of first getting to the right aspect. Then instead of running after the precedents, original thinking, you give a thought to originality, and then for that, you require understanding of the society. You require understanding of the society, you require understanding of the environment, you require to understand the human behavior. Then that you apply to a particular case. If you are able to, all these things doesn't take much.
That's right.
You are made to be aware of, these are all the things which I need to look into. You look into, then when your client comes, you need to behave well with him. You need to have a nice cordial relationship with him. You need to be giving more service than what you are paying for. Indian system. See, we are not in the US. We charge by hour or by minute. See, we have too many mouths to feed.
Right.
But unfortunately, we compare with American way, or we compare with what is happening in Europe, and we end up in a thing. Or the local, suppose a Mufsil area in West Bengal, man thinks he wants to charge the man like in Bombay. Is it possible? No, even in Hyderabad, now okay, some few of the people are doing it, but even today there is a lump sum fees is the what goes, and we do much more service. The concept of senior counsels or the senior this thing or per hour or per appearance, for all these things. This, in a way, our system can be afforded, except a few corporates or few these things. But then advocates, the lawyers or the people who come into profession, unfortunately, they compare differently, and then by the time they realize for 5-6 years is over, and then they get frustrated. This is what is happening.
Right. So it's, we have a lot to unpack in these discussions, and which is why we decided it'll be in 2 parts. So the first part would be about your life and the law, and the
I'm
second part would
sorry.
be more about the law. No, sir, not at all. It will be more about the specifics of the law and the technicalities. I would ask you the last question, and probably I'm pushing you a little into the controversial territory, but nonetheless, you spoke about the senior advocate designation. Now, we have seen repeated rounds of litigation before the Supreme Court, especially in the 𝐓𝐂𝐋𝐅 versus Supreme Court of India judgment in 2017, followed by in 2023, where objective criteria is being laid down as to how designation should happen across the country, which is possibly to bring in objectivity and to do away with the opaqueness allegedly that existed before this. How do you view that, sir? And with that, we'll wrap up this session and look forward to the second part.
Well, I'll answer that to start with. When I came into profession, there were hardly about 3 or 4 designated seniors in our High Court. Okay? My senior, and there are many other people whom we considered with a lot of reverence as a senior counsels. They all had refused a senior gown. The reason why is that there is a code of ethics when it comes to senior gown, especially not interacting with the clients, and the kind of litigation which is available or which is there in the particular area. It is not possible without interacting with the client. To start with, we would not like to breach that. We would not like to be dishonest with ourselves merely because we would like to get a gown. Number one. Number two, not much of importance was given to the gown in our high courts. Whether you are a designated senior or not is not recognized. You are a senior or not is not recognized by your gown. We normally jocularly we call it as Chatur. You know Chatur Puja, you understand, no? Four.
Yes. Yes.
No, so you are not really recognized as a senior merely because you have been designated. At one point of time, there were a large number of seniors who were designated, but who never had any brief. Okay. Unless you are recognized as a specialist in a particular subject. If you are a specialist in a subject and you are already recognized as a subject, whether gown is there or not doesn't make a difference. But today, gown is being asked in these parts more on account of the fact the law firms from the Delhi, Calcutta and all, they keep asking, I understand. My colleagues and all, they tell me, they ask designated senior. Okay. Merely because you are designated, that doesn't guarantee that you have a knowledge and expertise. And in the earlier system of designation, the court used to call for and confer the designation because the very fact that the court was calling and giving them the senior gown, that means entire of the judges as a community was recognizing so-and-so is the man who has expertise either in one branch or overall. So when they stood up, their word is taken to be gospel truth. Now, thanks to Indra Jaising and whatever she thinks that she has done a service, but today that's not gone because the so-called when you just like an examination, you put some criteria, you write articles, you get this marks, etc. Today, you know, it's like another examination.
That's right.
And then everybody gets a cut-off marks, and cut-off mark also gets varied many times by the decision of the full court for whatever reason. Like in Karnataka, they did that. Initially, they were about 30-40 people. Then they said, why only these people are getting eliminated? So, bring down the cut-off mark. With the result,
yes. 50 people got designated in one go in December 2020.
And many of them today, I understand from my friends, you know, because either they have to violate the code you need a briefing counsel.
Right.
Now you know that I don't think I should talk much about that.
That's why, sir, I prefaced it with a disclaimer that I'm probably pushing you into controversial territory. But that
No,
was...
I only...
So, you were saying something.
No, I was only telling, see, there are different kinds. There are people who are well-to-do, so they don't require any briefing, but they want a they want a gown.
Yeah.
There are people who really... Question is, why do I ask for a gown?
Right. So it was a real pleasure to have you with us today. We hope to unpack more in the second part of the podcast. For now, we'll take your leave. Thanks a lot.
Thank you.